Question 1. While investigating a complicated issue between different business competitors, a company claims that its competitor has been making false statements about its products to potential clients, leading to lost business. The statements were made during a trade conference and were published in an industry magazine. The plaintiff alleges defamation and demands damages. Which of the following statements is most accurate regarding the legal standard that applies? A. The plaintiff must prove that the statements were false, defamatory, and caused reputational harm, regardless of intent. B. The plaintiff must prove actual malice because it is a business defamation case and involves a matter of public concern. C. The plaintiff does not need to prove falsity, as defamation is presumed if harm is evident. D. The defendant can avoid liability if the statements were made without knowledge of their truth or even if negligently published. Answer B. The plaintiff must prove actual malice because it is a business defamation case and involves a matter of public concern. Explanation. This case falls under business defamation, which often involves trade libel or commercial disparagement. Since the false statements were made in a public forum, trade conference, and industry magazine, they likely concern a matter of public interest. Under New York Times Company v. Sullivan, 1964, when a defamation case involves public figures or matters of public concern, the plaintiff must prove actual malice, meaning the defendant knew the statement was false or acted with reckless disregard for the truth. Option is incorrect because defamation laws require falsity and false standards to be met. Private plaintiffs may have low burden negligence, but public matters require actual malice. Option C is incorrect because falsity must be proven unless the statement is defamatory per se, e.g., accusations of crime, professional misconduct. Option D is incorrect because negligence alone is insufficient when public concern is involved. A reckless disregard must be shown. Question 2. During a comprehensive review of a process that needs improvement, a manufacturer is sued for product liability after a consumer suffers severe injuries from using its industrial-grade machine. The consumer argues that the design was inherently dangerous despite adequate warnings and clear safety instructions. Under strict liability principles, which of the following defenses is most likely to absolve the manufacturer of liability? A. The manufacturer provided clear and sufficient warnings about the dangers associated with the product. B. The consumer misused the product in a manner that was not reasonably foreseeable. C. The consumer assumed the risk by purchasing and using an inherently dangerous product. D. The manufacturer adhered to the latest safety industry standards at the time of production. Correct answer, B. The consumer misused the product in a manner that was not reasonably foreseeable. Explanation. Strict product liability applies when a product is defective in design, manufacturing, or labeling and causes harm. However, misuse of the product is a valid defense if the misuse was not reasonably foreseeable. Courts generally assess whether an average consumer's behavior should have been anticipated by the manufacturer. Option is incorrect because while adequate warnings can sometimes prevent liability for failure to warn, they do not absolve manufacturer if the product is defectively designed. Option C is incorrect because assumption of risk is only defense when the consumer had full knowledge of the danger and voluntarily accepted it. This is high bar to meet. Option D is incorrect because adherence to industry standards does not automatically shield manufacturers from liability. Product can still be defective despite meeting industry standards if the design poses unnecessary risks. Question 3. When implementing new protocols in a shared environment, a hospital is sued for medical malpractice after a patient claims that a doctor's failure to obtain informed consent led to unexpected complications. The patient argues that they were not informed of serious but rare risk associated with the procedure. What is the most critical factor in determining whether the doctor failed in their duty to disclose? A. Whether the doctor personally believed the risk was too insignificant to disclose. B. Whether other doctors in the same specialty would customarily disclose the risk. C. Whether the patient was provided with general consent form before the procedure. D. Whether the risk was so rare that it did not need to be included in standard disclosures. Answer. B. Whether other doctors in the same specialty would customarily disclose the risk. Explanation. Medical malpractice claims based on lack of informed consent require proof that the doctor failed to disclose material risks that a reasonable physician in the same field would have disclosed. Courts often apply an objective standard based on customary practices among similarly trained professionals. Option is incorrect because the doctor's personal belief about risk significance is not the standard. What matters is how a reasonable doctor in the field would act. Option C is incorrect because general consent form does not absolve liability if critical risks were omitted. Courts require specific disclosure of known risks even if rare. Option D is incorrect because even rare risks must be disclosed if they are severe enough that reasonable patient would want to know. Risk-benefit analysis is essential. Question 4, topic: negligence. Duty of care and proximate cause. In an environment where different components must interact seamlessly to ensure public safety, manufacturing company produces specialized chemical used in water purification. The chemical is sold in bulk to distributor, which then sells it to municipal water treatment facilities. Due to an error in labeling at the manufacturing stage, the chemical is mistakenly labeled with concentration than it actually contains. Water treatment plant, following standard dilution procedures based on the label, fails to properly purify the water, resulting in bacterial outbreak that leads to illness in thousands of residents. An independent auditor later finds that while the manufacturer mislabeled the product, the water treatment plant failed to test the chemical's effectiveness as required by industry regulations. Who is most likely held liable, and under what negligence principles? A. The manufacturer, because mislabeling constitutes negligence per se. B. The distributor, because it has duty to inspect and confirm accuracy before reselling. C. The water treatment plant, because it had an independent duty to test and verify effectiveness. D. No one, because the outbreak was an unforeseeable chain of events. Answer: C. The water treatment plant, because it had an independent duty to test and verify effectiveness. Explanation: negligence liability requires proving 1. Duty, 2. Breach, 3. Causation, and 4. Damages. Here, multiple parties may have played a role, but the key issue is whether their negligence was approximate cause of the harm. The manufacturer mislabeled the product, but under Palsgraf v. Long Island Railroad, foreseeability is key to proximate cause. A mislabeled concentration is not necessarily foreseeable to cause. A bacterial outbreak, especially when intermediate testing, is an expected safeguard. The distributor might have a general duty of care but is not typically responsible for inspecting and verifying product formulations unless there is a known defect. The water treatment plant had an industry-mandated duty to test the chemical. Its failure to do so is a superseding cause, breaking the chain of causation from the manufacturer's mislabeling. This aligns with Hines v. Garrett, where an intervening act by a third party can negate earlier negligence. Option D is incorrect because the outbreak was foreseeable if the plant failed in its duties. This question tests duty of care, causation, and foreseeability, all of which are crucial in negligence analysis. Question 5, topic: intentional torts. False imprisonment and defenses during an emergency response where multiple areas are impacted by crisis. Store manager detains customer inside locked office believing that the customer is attempting to shoplift during chaotic evacuation due to gas leak. The manager refuses to release the customer even after reviewing security footage that does not clearly show theft. The police arrive 45 minutes and determine there was no probable cause to arrest the customer. The customer later sues the store for false imprisonment. Which of the following legal principles applies in determining liability? A. The store is liable because the detention exceeded reasonable amount of time. B. The store is not liable because private citizens can detain others on reasonable suspicion. C. The store is liable because the detention occurred in an emergency scenario. D. The store is not liable because security footage was inconclusive. And so A. The store is liable because the detention exceeded a reasonable amount of time. Explanation: false imprisonment occurs when a person is intentionally confined without legal authority, consent, or justification. The elements include 1. An act of restraint, 2. Confinement within a bounded area, 3. The plaintiff's awareness of confinement, and 4. No lawful justification. The store's defense relies on the shopkeeper's privilege, which reasonable detention of suspected shoplifters, Collier v. S. H. Kress and Ompany. However, for the defense to apply, the detention must be reasonable in duration and manner. Here, 45 minutes is excessive, especially after reviewing the footage. Option B is incorrect because the standard is reasonable suspicion, but even when initially justified, continued detention after reviewing the footage is unreasonable. Option C incorrectly implies that emergency conditions justify unlawful restraint. False imprisonment laws still apply in emergencies. Option D is incorrect because shopkeepers must act on clear evidence and inconclusive footage is not enough to justify prolonged detention. This question challenges students to evaluate false imprisonment and shopkeepers' privilege, emphasizing time as critical factor. Question 6. Topic: Strict liability. Product liability and defenses in multi-location scenario where consistency requirements are crucial. Nationwide toy manufacturer produces series of children's playsets. One of the components, small detachable piece, presents choking hazard leading to several injuries. Parents of injured children file product liability lawsuit under strict liability. During the trial, the company argues packaging contained clear warning about small parts and that parents failed to follow the warning. Under strict liability principles, how will the court likely rule? A. The manufacturer is liable because product warnings do not absolve liability for defective design. B. The manufacturer is not liable because the warning was adequate and provided sufficient notice. C. The manufacturer is liable only if the design defect was result of gross negligence. D. The manufacturer is not liable if the injuries resulted solely from parental negligence. Answer A. The manufacturer is liable because product warnings do not absolve liability for defective design. Explanation: strict liability in product cases follows the restatement 2nd of Torts SSA, which states that manufacturer is liable if product is unreasonably dangerous due to defect regardless of intent or negligence. Warnings versus defective design. Warning does not excuse an inherently dangerous design. Consumer expectations test as used in Sol v. General Motors Corp. And a risk utility test, balancing costs of alternative design versus risks both apply. Option B is incorrect because while adequate warnings are relevant, they do not negate liability if safer design was possible. Anderson v. Owens Corning Fiberglass. Option C is incorrect because strict liability does not require gross negligence. Defect alone establishes liability. Option D is incorrect because parental negligence is not complete defense in strict liability unless it is the sole proximate cause, which is rare. Dolly v. General Motors. This question ensures students understand design defects, strict liability principles, and limits of warning defenses. Question 7. While investigating a complicated issue between different parties, a plaintiff alleges that a large retail chain is liable for defamation due to statements made by one of its employees. The employee, without authorization, falsely accused a customer of shoplifting over a store loudspeaker. The customer suffered reputational harm and emotional distress. Under what circumstances could the retail chain be held liable? A. The retail chain is always liable for any employee's actions, regardless of the scope of employment. B. The retail chain is liable if the employee acted within the scope of employment or if the statement was made in furtherance of the employer's interests. C. The retail chain cannot be held liable because defamation is an intentional tort and employers are only liable for negligence. D. The retail chain can only be held liable if the plaintiff can prove that upper management personally directed the employee to make this statement. Answer B. The retail chain is liable if the employee acted within the scope of employment or if the statement was made in furtherance of the employer's interests. Explanation: this question examines vicarious liability, respondit superior, in defamation cases. Under this doctrine, an employer may be liable for an employee's tortious conduct if it occurs within the scope of employment or in furtherance of the employer's business interests. A. Incorrect. Employers are not automatically liable for all employee actions. Liability depends on whether the employee was acting within their job duties. B. Correct. If the employee made the statement while performing job-related duties, e.g. loss prevention, the employer may be held responsible. Even unauthorized acts can trigger liability if they are sufficiently connected to employment. C. Incorrect. Employers can be liable for intentional torts, including defamation, if committed within the scope of employment. D. Incorrect. Direct involvement by management is not requirement for liability under respondit superior. Relevant legal principles. Restatement 2nd of Agency SS 219 and defamation law under law principle. Question 8. During a major transformation where existing methods of communication are changing, a well-known journalist publishes an article accusing a private business owner of fraud. The business owner sues for defamation, arguing the article contained false statements. The journalist claims the statements were based on anonymous sources. What must the plaintiff prove to succeed in? A defamation lawsuit. A. That the statements were false and that they were made with actual malice. B. That the statements were false and that the journalist failed to use anonymous sources. C. That the statements were merely offensive but not necessarily false. D. That the statements harmed the plaintiff's reputation regardless of their truthfulness. Answer D. That the statements harmed the plaintiff's reputation regardless of their truthfulness. Explanation. Defamation requires false statement of fact, publication, harm to reputation, and fault, negligence, or actual malice, depending on the plaintiff's status. A. Incorrect. Actual malice standard applies only to public figures. New York Times Company v. Sullivan. The plaintiff here is private business owner, so lower negligence standard applies. B. Incorrect. The use of anonymous sources does not automatically make statement defamatory. C. Incorrect. Mere offensiveness is not sufficient. The statement must be false and damaging. D. Correct. The plaintiff must prove falsity and reputational harm. Even if the journalist relied on anonymous sources, if the statements were false and caused harm, the plaintiff may succeed. Relevant law. New York Times Company v. Sullivan, 1964. Gertz v. Robert Welch, Inc., 1974. Question 9. While analyzing the root causes of sequential problems in workplace safety, an employee is injured when a forklift malfunctions due to a defective brake system. The employee sues both the forklift manufacturer and their employer. Under which legal theory might the manufacturer be strictly liable? A. The manufacturer is strictly liable if the defect made the forklift unreasonably dangerous when used as intended. B. The manufacturer is strictly liable only if the defect resulted from intentional misconduct. C. The manufacturer is not liable if the employer failed to inspect the forklift before use. D. The manufacturer can avoid liability if the employee was trained to identify mechanical issues. Answer A. The manufacturer is strictly liable if the defect made the forklift unreasonably dangerous when used as intended. Explanation. This question examines product liability and the doctrine of strict liability under restatement. Second of Torts SS 402A. A. Correct. Manufacturers are strictly liable for defective products that are unreasonably dangerous when used as intended. This applies to manufacturing defects, design defects, and failure to warn. B. Incorrect. Strict liability does not require intentional misconduct, only that the product was defective and caused harm. C. Incorrect. The employer's failure to inspect does not absolve the manufacturer of liability. The defect existed at the time of sale. D. Incorrect. The employee's training does not eliminate the manufacturer's duty to provide safe product. Relevant cases. Greenman v. Uber Power Products, Inc., 1963. Escola v. Coca-Cola Bottling Company, 1944. Question 10. In a high-stakes environment where multiple challenges arise, a construction company is sued for nuisance after its demolition activities cause excessive dust, noise, and vibrations in a residential neighborhood. What is the most likely factor in determining liability? A. Whether the construction company obtained all necessary permits. B. Whether the interference was substantial and unreasonable. C. Whether the neighbors signed a waiver agreeing not to sue. D. Whether the company can prove it followed industry safety standards. Answer B. Whether the interference was substantial and unreasonable. Explanation. This question addresses private nuisance law, which requires substantial and unreasonable interference with another's use and enjoyment of land. A. Incorrect. Permits do not shield company from liability if its activities cause unreasonable harm. B. Correct. The key test for nuisance is whether the interference is substantial and unreasonable. Restatement. Second of Torts SS 820 and C. Incorrect. Waiver may limit liability but does not necessarily bar all claims. D. Incorrect. Compliance with industry standards does not automatically prevent liability if the activity is still unreasonably disruptive. Relevant law. Boomer v. Atlantic Cement Company, 1970. Spur Industries, Inc. v. Delhi Web Development Company, 1972. Question 11. During a comprehensive review of a process that needs improvement, a major industrial manufacturer discovers that its product has a potential defect that could cause harm under specific but rare circumstances. However, fixing the issue would be costly and the probability of harm occurring is low. Under product liability principles, what is the company's potential legal exposure if they choose not to act? A. The company is not liable because the defect is rare and has not yet caused harm. B. The company may be liable under strict liability if the product has design defect that makes it unreasonably dangerous. C. The company is only liable if there is manufacturing defect, not design flaw. D. The company will not be liable if it includes disclaimer in the product manual. Answer: B. The company may be liable under strict liability if the product has a design defect that makes it unreasonably dangerous. Explanation: under strict liability, a company can be held liable for a design defect if the product is unreasonably dangerous when used as intended. Courts often apply the risk-utility test, which weighs the feasibility and cost of a safer design against the risk posed by the current design. Even if the defect is rare, liability may arise if the company knew or should have known about the risk but failed to act. Disclaimers in product manuals do not typically absolve a manufacturer of liability under restatement third of torts, products liability. Question 12. In a high-stakes environment where multiple challenges arise in succession, a hospital is sued for medical malpractice when a patient develops complications after surgery. The patient claims that the hospital staff failed to follow the correct post-operative protocol, which led to an infection. However, the hospital argues that the patient's infection resulted from an unforeseeable allergic reaction. Under negligence principles, which factor is most critical in determining the hospital's liability? A. Whether the hospital's actions deviated from the standard of care expected in similar circumstances. B. Whether the hospital can prove that the patient had pre-existing condition. C. Whether the patient signed an informed consent form before surgery. D. Whether the patient had an alternative medical facility available for treatment. Answer A. Whether the hospital's actions deviated from the standard of care expected in similar circumstances. Explanation: negligence in medical malpractice cases hinges on whether the healthcare provider deviated from the standard of care expected under similar circumstances. Courts will analyze medical protocols, expert testimony, and the but-for causation, whether the infection would have occurred but for the hospital's actions. The presence of an informed consent form does not excuse negligence in post-operative care. Restatement, 2nd of Torts SS 299 year outlines heightened duty for professionals, requiring them to act in accordance with the knowledge and skill of the profession. Question 13. While investigating a complicated issue between different business entities, a company sues its competitor for defamation, claiming that the competitor published false information about its financial stability. What must the plaintiff prove to succeed in a defamation claim? A. The statement was an opinion rather than a fact. B. The statement was false, published to a third party, and caused reputational harm. C. The competitor intended to harm the plaintiff's business operations. D. The statement was made in private setting, not publicly disclosed. Answer B. The statement was false, published to a third party, and caused reputational harm. Explanation: to succeed in a defamation claim, the plaintiff must prove 4 elements. False statement: the statement must be false and not an opinion. Publication: the statement must be communicated to a third party. Harm: the statement must damage the plaintiff's reputation. Fault: if the plaintiff is a public figure, they must also prove act. Malice: knowledge of falsity or reckless disregard for the truth. Per New York Times Company v. Sullivan, 1964. Mere intent to harm, option C, is not necessary element unless intentional interference with business relations is also alleged. Question 14. During an emergency response where multiple areas are impacted, a government agency authorizes the destruction of private property to prevent the spread of wildfire. The property owner sues for damages. Under what legal doctrine might the government avoid liability? A. The government is strictly liable for property destruction. B. The government can invoke the doctrine of necessity. C. The government must compensate the owner under eminent domain principles. D. The government is only liable if the destruction was intentional. Answer B. The government can invoke the doctrine of necessity. Explanation: under the doctrine of public necessity, government entities or even private individuals may destroy private property without liability to prevent greater harm to the public. This principle was established in cases such as Sarko v. Geary, 1853, where destruction of property to stop a fire was deemed justified. Eminent domain, option C, applies when the government takes property for public use, but necessity applies in emergencies. Question 15. In a case where multiple parties have different objectives, a landowner sues a neighboring factory for causing foul odors that interfere with the enjoyment of their property. What type of tort is most applicable? A. Defamation. B. Private nuisance. C. Trespass to land. D. strict liability for ultra-hazardous activity. Answer B. Private nuisance. Explanation. A private nuisance occurs when an activity unreasonably interferes with another's use and enjoyment of their property. Unlike trespass, which requires physical invasion, nuisance can involve intangible interferences like odors or noise. Restatement. Second of Torts SS 820 defines nuisance as substantial and unreasonable invasion of property rights. Question 16. When improving a process that shows unexpected results, a retail store owner sets up hidden surveillance cameras to monitor employees. One employee sues for invasion of privacy. Under what circumstances might the employer be liable? A. If the surveillance was in a private area, such as a restroom. B. If the employer did not inform employees about general store security policies. C. If the employer stored footage for longer than 30 days. D. If employees were recorded during work hours. Answer A. If the surveillance was in a private area, such as a restroom. Explanation. The tort of intrusion upon seclusion occurs when an individual intentionally intrudes into another's private affairs in highly offensive manner. Courts consider whether the individual had reasonable expectation of privacy. Catesby, United States, 1967, established the test for reasonable expectations of privacy, which applies in tort law as well. In public work areas is generally permissible, but monitoring bathrooms or changing areas violates privacy rights. Question 17. During a major transformation where existing methods are challenged, a physician is sued for failing to inform a patient about an experimental treatment's risks. Which legal principle is most relevant? A. Strict liability. B. Informed consent. C. Assumption of risk. D. Comparative negligence. Answer B. Informed consent. Explanation. Informed consent requires medical professionals to disclose risks, benefits, and alternatives to treatments. Failure to do so can lead to liability even if the treatment itself is performed competently. Courts apply Canterbury v. Spence, 1972, which states that a physician must disclose information that a reasonable patient would consider material to their decision. Question 18. In an environment where different components must interact efficiently, a software developer discovers that their company's new software update has serious security flaw that could expose users' personal data. The company's management decides to delay fixing the issue to avoid negative press. If customers' data is leaked due to this known flaw, under what tort theory might the company be liable? A. Intentional misrepresentation. B. Negligent misrepresentation. C. Negligence. D. Trespass to chattels. Answer C. Negligence. Explanation. Negligence occurs when a party fails to exercise reasonable care, resulting in harm. Here, the company knew about the risk yet failed to act, which breaches the duty of care owed to users. Courts may apply the Hand formula from United States v. Carroll Tone Company, 1947, to assess whether the burden of fixing the flaw is outweighed by the likelihood and severity of harm. Misrepresentation, fraud, option A, requires affirmative, false statements, while trespass to chattels, option D, applies to physical interference with personal property. Question 19. When implementing backup procedures across various departments, a delivery driver is injured by a company's failure to maintain safe loading dock. The driver sues the company under premises liability. What must the driver prove to establish the company's negligence? A. The company's management was directly involved in causing the hazard. B. The company knew or should have known about the dangerous condition and failed to fix it. C. The company's employees had no prior complaints about the condition. D. The driver was invited to the premises as paying customer. Answer B. The company knew or should have known about the dangerous condition and failed to fix it. Explanation. Under premises liability, a property owner owes a duty of care to invitees such as delivery drivers. The key element is whether a company knew or should have known about the hazard and failed to address it. The standard is reasonable foreseeability, as outlined in Rowland v. Christian, 1968. Actual management involvement, option A, is not required. Constructive knowledge suffices. Question 20. During a seamless transition where continuity must be maintained, an airline passenger is injured when turbulence causes a service cart to strike them. The passenger sues the airline for negligence. What legal doctrine might automatically impose liability on the airline? A. Respondit superior. B. Res ipsa loquitur. C. Strict liability. D. Assumption of risk. Answer B. Res ipsa loquitur. Explanation. Res ipsa loquitur. The thing speaks for itself applies when the incident would not normally occur absent negligence. If the defendant had exclusive control over the instrumentality, airline controls the cut, and the plaintiff did not contribute to the harm. Since passengers have no control over turbulence and airline equipment, liability may be inferred under Byron v. Bodle 1863. Airline could also be liable under common carrier negligence standards, which impose higher duty of care. Question 21. In a situation where formal requirements conflict with practical needs, a homeowner hires a contractor to install a new staircase. The contractor negligently builds it with weak materials, causing the staircase to collapse, a week later injuring a visitor. Under what legal theory might the visitor sue the contractor? A. Strict liability. B. Breach of contract. C. Negligence. D. Intentional infliction of emotional distress. Answer. C. Negligence. Explanation. Negligence applies because the contractor owed a duty of care to ensure safe construction, breached that duty and directly caused harm. Breach of contract. B. is relevant only between the homeowner and contractor, not the injured visitor. Strict liability. A. is reserved for inherently dangerous activities, and D. requires extreme outrageous conduct. Question 22. While analyzing the root causes of sequential problems in consumer safety, a toy manufacturer releases a new product with small detachable parts posing a choking hazard. After multiple reports of injuries, the company refuses to issue a recall. Under what legal doctrine might the company be held liable? A. Respondit superior. B. Strict liability. C. Comparative negligence. D. Negligence per se. Answer. B. Strict liability. Explanation. Strict liability applies in product liability cases, meaning the manufacturer is liable even if they exercised reasonable care. The toy had a defective design, making it inherently dangerous. Negligence per se. D. applies when violating a law, but no recall law is broken. Comparative negligence. C. applies when the plaintiff shares fault. Question 23. In a high-stakes environment where multiple challenges arise simultaneously, a driver runs a red light while texting and collides with another car. The injured driver sues, but it is discovered that they were speeding. Under a pure comparative negligence rule, what happens to the damages? A. The texting driver is completely barred from recovery. B. The injured driver recovers damages, but they are reduced by their percentage of fault. C. The injured driver can only recover if they were less than 50% at fault. D. The injured driver cannot recover any damages. Answer. B. The injured driver recovers damages, but they are reduced by their percentage of fault. Explanation. Under pure comparative negligence, each party's damages are reduced based on their fault percentage. If the injured driver was 30% at fault, they would recover 70% of damages. Option C describes modified comparative negligence, which applies in some states. Question 24. During an emergency response where multiple areas are impacted, the bystander at a car accident pulls an unconscious driver from a burning vehicle but accidentally fractures the driver's arm in the process. If the driver sues for battery, what legal defense is most applicable? A. Assumption of risk. B. Self-defense. C. Necessity. D. Good Samaritan law. Answer. D. Good Samaritan law. Explanation. Good Samaritan laws protect rescuers from unintentional harm caused while providing emergency aid. The bystander acted reasonably under exigent circumstances. Necessity C applies to property damage, while assumption of risk A applies to voluntary participation in dangerous activities. Question 25. When improving a process that shows unexpected results, a company installs security cameras in employee break rooms without notifying staff. An employee sues for invasion of privacy. What legal principle applies? A. Intrusion upon seclusion. B. Defamation. C. False light. D. Public disclosure of private facts. Answer A. Intrusion upon seclusion. Explanation. Intrusion upon seclusion occurs when someone intentionally invades another's private space in a way that is highly offensive. Employees have reasonable expectation of privacy in break rooms. False light C involves misleading public portrayals, and public disclosure D requires sharing private facts. Question 26. In a multi-location scenario where consistency requirements are high, a journalist falsely accuses a local restaurant of using expired ingredients, leading to a sharp decline in business. The restaurant sues for defamation. What must the restaurant prove? A. The journalist intended to harm the restaurant. B. The statement was false and caused economic harm. C. The statement was based on an opinion. D. The statement was made without any sources. Answer B. The statement was false and caused economic harm. Explanation. To establish defamation, the restaurant must prove the statement was false, published, and caused reputational harm. Intent to harm A is not required. Opinions C are not defamatory unless presented as fact. Question 27. While updating traditional approaches where interconnections matter, a social media platform's algorithm mistakenly flags businesses' advertisements as misleading, blocking their account. The business loses thousands of dollars. What legal theory could they use to sue the platform? A. Breach of contract. B. Defamation. C. Product liability. D. Intentional infliction of emotional distress. Answer A. Breach of contract. Explanation. Most social media companies operate under terms of service agreements, making breach of contract the strongest claim. Defamation B. requires a false factual statement, and D. requires extreme conduct. Question 20. During a major transformation where existing methods are being overhauled, a company releases an energy drink with misleading health claims stating it prevents heart disease. The customer sues after experiencing heart complications. What legal claim is most relevant? A. Fraud. B. Negligence. C. False advertising. D. Trespass to chattels. Answer C. False advertising. Explanation. False advertising occurs when a company intentionally misrepresents a product, benefits. The Lanham Act and Federal Trade Commission (FTC) regulations prohibit deceptive health claims. Question 29. In a case where multiple parties have different objectives, a city's new waste management contract forces small waste collection businesses out of operation. The business owners sue under antitrust laws, arguing the contract unfairly eliminates competition. What legal claim applies? A. Restraint of trade. B. Tortious interference. C. Negligence. D. False imprisonment. Answer A. Restraint of trade. Explanation. Restraint of trade occurs when contracts unreasonably restrict competition under antitrust law. Tortious interference B. applies to interfering with specific business relationships, while negligence C. requires the duty of care. Question 30. When scaling up operations that experience significant risks, an amusement park rider suffers an injury after a safety harness fails. The park argues that the rider assumes the risk by participating. What legal doctrine might limit the rider's recovery? A. Assumption of risk. B. Res ipsa loquitur. C. Strict liability. D. Public nuisance. Answer A. Assumption of risk. Explanation. Assumption of risk applies when a person knowingly engages in a dangerous activity, g. roller coasters. However, if negligence is extreme, this defense may not apply.